Hi, I'm Bob Scrivano, the CEO and founder of Assets and Aging. For 30 years, helping seniors and the families of seniors find solutions to the issues of aging. Remember, I'm not an attorney, I don't practice law, I don't give legal advice, and also everything we talk about here is our opinion only and is based on current rules and regulations. If you want to talk to an attorney, you should consult one, and I happen to have one here with me, and he is...
Hi, thank you, Bob. I'm Gary Lieberman. I'm an elder law attorney. I've been in the private practice of law for 33 years. The main focus of our practice is estate planning and asset protection planning for seniors and their families.
Gary, we're going to talk about powers of attorney. And there's lots of them, but there's basically two kinds of powers of attorney. One that deals with finance and one that deals with health care. Kind of briefly describe the difference. I think most people understand the difference, but kind of what's the difference between the two?
Well, they're both generally known as durable power of attorneys. One is a durable power of attorney for finance, management of financial affairs. The other is what's called an advanced health care directive. It authorizes someone to make health care decisions if you're unable to do so.
And both of those are important documents, and they're generally not combined, are they?
No, in fact, by law, they have to be two separate documents.
Especially here in California?
Yes.
Okay. Now, given those two powers of attorney, we're going to add two more things to it here. Powers of attorney can be either springing or non-springing. Again, in layman's terms, explain the difference between those and how people can determine what they have.
A springing power of attorney is a power of attorney that does not come to life, does not come into being. You can't use it until you're declared incompetent or incapacitated by two licensed physicians. Versus the immediate power of attorney, which is valid and effective as soon as you sign it. Doesn't mean you need to use it then, but it can be used immediately.
So if I have a springing power of attorney and dad becomes ill, mom doesn't really have dad's power of attorney until she first has him declared incompetent.
Or incapacitated, by two licensed physicians.
And is that something that in most families we want to have the spouse or the children running around having their spouse or mom or dad declared incompetent?
Absolutely not.
Not really a good idea in most cases. But an immediate power of attorney, a non-springing power of attorney, is in effect when?
As soon as it's signed.
As soon as the minute it was signed, right?
Yes, absolutely.
So now dad or mom or whoever or the children can manage mom's affairs, manage dad's affairs from the very get-go.
Absolutely, and there's no necessity that they get two licensed physicians to write a report that says dad is incompetent.
And that's really important, folks, in my experience, and I know in Gary's, with people who have dementia. Especially in the beginning, they have good days, they have bad days. They remember one day, they don't remember the next day. Do you really want to have your loved one declared incompetent just so you can pay the bills and make medical decisions and get insurance records and those kinds of things? One other thing, and this is important, trusts are trusts and powers of attorney are powers of attorney. Do the two meet?
They do not. Typically, they do not. They need to, what we call, speak to one another in terms of allowing modification of a trust and so on. But the power of attorney deals with assets which are non-trust assets. IRAs, insurance policies, insurance claims, pension,
taxes,
that sort of thing. Whereas the trust document controls what you can do or cannot do with assets which are in the trust.
So if my house is in the trust, the controlling document is the
trust agreement.
Is the trust,
right.
Not the powers of attorney. And that's something that people quite often get very confused about, isn't it?
Yes, they do.
They're very confused about. So what are some of the authorities? Let's assume that you've said an immediate power of attorney or non-springing power of attorney is better. What are authorities, other than the normal stuff like writing checks and those kinds of things, what are some of the authorities that need to be in them? And then I want to talk about something called HIPAA. But what are some of the things, in particular in a power of attorney for property, that really need to be there?
Well, some of the most important things are, number one, the authority, the authority and the right to establish a trust for someone, or to change or modify a trust, and perhaps establish an irrevocable trust. The authority to make gifts, to transfer assets between either the spouses or the children. The authority to apply for public benefits, for government benefits, which may include Social Security, may include veterans benefits, and generally speaking, handle issues which deal with, again, with frailty. What do I do if I get sick and I need assistance with handling any aspect of my financial affairs.
And it's really important that those are logged in there, that they say that. Lots of people have a power of attorney that on the front page just has a bunch of little checkoff boxes.
Right.
And the very last box says all of everything, or all. Is there ever a circumstance in which everything means everything?
No, there isn't. There isn't. In fact, another essential provision which must be in there by law is the right to make gifts on behalf of the person that you're acting for, your principal. You have to have specific authority to make a gift or transfer of an asset.
So it's very important that documents say what we really need to do, and it has to be very specific.
Absolutely.
Let me talk about HIPAA, or as some people call it, HIPAA regulations. HIPAA. What's HIPAA, and why is it important, and why do most powers of attorney before 2003 not have this?
Well, HIPAA is an acronym for the Health Insurance Portability and Accountability Act. Excuse me, it's the law of the land, and it deals with privacy. And basically what it says is unless your documents have very specific language, which is directly from the HIPAA regulations, if that language is not in the documents, then no one is authorized to release any of your personal, private, or healthcare information to anyone under any circumstances.
Well, hang on a second. We're going to do a little role playing here. Hang on a second. It's my wife. Can't my wife get any medical information she wants? She's my wife.
Absolutely not. Not unless the document complies with the HIPAA rules.
They're my children. Are you telling me that if something happened to me, my children can't just get any information? They're my kids. I love them. I want them to have all my stuff.
That's exactly right. The law is very specific, and it has criminal penalties, by the way, attached to it if you violate the law. Unless the language is specifically in the documents, then technically they're not allowed to release any private information.
So if you're not sure what your documents say, you're not sure what your powers of attorney say, you're not even sure if you have them, call the number at the bottom of your screen. We'll arrange a free consultation. We'll get you the answers that you need and make sure that you're on the road to being protected and your family being protected. Thanks for watching, and take a look at the other videos that are attached and a part of this website. Thanks so much.